Tupac Shakur was murdered on September 13, 1996. Nearly 30 years later, the only man ever charged still hasn't faced trial. His third defense lawyer just quit. The trial date has been pushed 5 times. The defense now claims someone else did it, and the man who spent years publicly confessing wants every word thrown out. A case built on the defendant's own admissions is falling apart in real time. Court calendars in Clark County have rarely seen a murder trial slip this many times. The first date, June 3, 2024, was set with the kind of formulaic confidence reserved for open and shut cases. 6 months for discovery, then the evidence would speak for itself. But the docket tells a different story, one of momentum leaking out with every reset. On August 21, 2024, the first continuance landed. The official reason was that defense counsel Carl Arnold withdrew after his client, Duane Davis, was convicted in a jailhouse assault. The minute order notes pending disciplinary review. The trial moved to November 12, 2024. November did not hold. By early October, Davis's new legal team filed a motion citing voluminous forensic and digital evidence. The court, acknowledging the sheer scale of the prosecution's files, granted more time. The new date was March 4, 2025. That extension, too, would prove temporary. In March 2026, the defense fractured again. Lead attorney Draskovich withdrew, this time over a retainer fee dispute. The official record reads, "Defendant is now unrepresented. Trial cannot proceed without a lead attorney." The calendar reset to February 19, 2026. But even that proved optimistic. On February 17, 2026, the court denied a defense motion to suppress evidence from a 2023 nighttime search. Yet the denial came bundled with another reason to delay. New forensic reports and witness statements, still under review, made the trial calendar untenable. The court's language is clinical, but the effect is clear: another postponement. August 10, 2026 now stands as the 5th date. Each shift is recorded in minute order language, detached, procedural, almost bureaucratic in tone. But the reality is anything but routine. 5 trial dates, each with its own paper trail and justification. What began as a prosecution built almost entirely on the defendant's own words has been swallowed by the machinery of legal delay. The calendar, once a tool of order, now reads like a warning that justice, even in the highest profile case on the docket, is not guaranteed by the passage of time. Somewhere behind the scenes, the unseen hand of the scheduling clerk keeps typing new dates, as if the clock itself is losing patience. 3 separate defense teams have cycled through Duane Davis's murder case, each departure leaving the trial date in limbo. Carl Arnold, the first to represent Davis after his 2023 arrest, withdrew in August 2025. His exit followed Davis's conviction for a jailhouse assault, triggering a disciplinary review that forced Arnold to step aside. The court's minute order records the withdrawal with the kind of bureaucratic detachment that belies its impact. Without counsel, the trial could not proceed, so the date moved from June to November 2024. The next team, led by Robert Draskovich and Maria Pandulo, took on the case with a new strategy to bury the prosecution under the weight of voluminous forensic and digital evidence. In October 2024, their motion described a mountain of files, including thousands of pages of police reports, hours of video, and a digital trail stretching back decades. The court agreed, giving the defense more time and pushing the trial to March 2025. but the evidence review became a moving target. As new disclosures arrived, expert reports, witness lists, and supplemental lab results, the task kept expanding. The defense's argument was simple. With so much at stake, no one could responsibly proceed without a full accounting of the state's case. Yet even that extension was short-lived. On March 10, 2026, Draskovich filed a formal notice of withdrawal. The reason this time was financial. A retainer dispute with $75,000 at issue and no resolution in sight. The court's record is blunt. Defendant is now unrepresented. Trial cannot proceed without a lead attorney. Another reset followed, this time to February 19, 2026. The calendar became a casualty of legal attrition, each lawyer's exit multiplying the delays. By late March 2026, the court scheduled a hearing to appoint new counsel. The docket now reflected 3 distinct legal teams, none of which had seen the inside of a jury box. Each turnover meant new attorneys had to master a sprawling evidentiary record from scratch. Every withdrawal forced the court to halt proceedings, reset the clock, and issue a new round of discovery deadlines. The effect was cumulative. What began as a straightforward prosecution built on Davis's own admissions had become a procedural maze, where the absence of a stable defense team was not just a technical problem, but a central obstacle to ever-reaching trial. The case's fragility is now measured in attorney withdrawals as much as in evidence or witness lists, a legal marathon with no finish line in sight. The core of the prosecution's case is built on Duane Davis's own words, spoken, written, and broadcast to millions. Prosecutors have assembled a catalog of interviews, documentary appearances, and memoir passages, each treated as a direct admissions of involvement. In the 2024 ABC jailhouse interview, Davis insisted he was at home in Los Angeles on the night Tupac was killed, offering an alibi and denying any role. But in earlier media, and most notably in his 2019 memoir, he described orchestrating the crew and laying out the plan. Pages 45 to 48 of Compton Street Legend, now entered as Exhibit B, spell out in plain language that Davis claims he put together the crew, gave the money, and set the plan in motion. Prosecutors have authenticated every recording and manuscript with sworn affidavits and chain of custody logs. Each exhibit is stamped and cataloged in the court record, from the unedited ABC master tape to the notarized manuscript of the memoir. The defense tried to suppress much of this material, arguing the interviews were selectively edited and the book's authorship was in doubt. But on February 17, 2026, the court denied the suppression motion, ruling that Davis's statements were voluntary and admissible under Nevada's rules for party admissions. The evidence, once considered the prosecution's ace, now stands as both the backbone and the battleground of the case, its strength and its risk exposed with every new motion. The defense's latest maneuver landed with the force of a last-minute sidestep. A private investigator, Angela Mendoza, filed an affidavit claiming Duane Davis was nowhere near Las Vegas on the night Tupac was killed. Her report points to hotel records and a credit card receipt from Albuquerque, New Mexico, and lists 6 witnesses who would swear Davis was out of state. The defense bundled this affidavit into a formal motion, arguing that the prosecution's case is built on the wrong man. But the document goes further, naming Reggie Wright Jr., a former death row record security chief, as the real orchestrator of the crime. Wright Jr., confronted by reporters, called the accusation a baseless attempt to muddy the waters. Payroll records and a public denial place him in Compton, not Las Vegas, on September 13, 1996. Still, the defense's strategy is clear. Generate enough uncertainty to fracture the narrative and keep the trial from ever reaching a clean conclusion. Each new filing shifts the ground under the case, forcing the court to pause, reconsider, and reset the clock once again. In February 2026, Duane Keefe D. Davis signed an exclusive agreement with Pioneer Productions, a British documentary company promising unfettered access to the accused throughout the trial. The contract filed with the court grants Pioneer the rights to film interviews before trial, behind-the-scenes strategy sessions, and Davis's personal reflections, all in exchange for a flat fee of $750,000 and a cut of future profits. Court records confirm the deal is unlike anything seen in a Nevada murder case. Legal analysts split instantly. Some call it a bold act of confidence, a defendant so sure of his story he will let cameras roll as the prosecution tries to use his own words against him. Others see a disaster in the making, warning that every unscripted moment could become fresh ammunition for the state or grounds for mistrial if it taints the jury pool. Judge Carla Ruiz, overseeing the contract's review, ordered the footage sealed until after the verdict and warned of contempt for any leak. Pioneer's counsel insists the arrangement is a hedge against media distortion, while critics argue it is a reckless gamble that could backfire in ways no one can predict. In a case already tangled by years of delays and shifting defense teams, the decision to invite a film crew into the heart of the legal chaos raises a question. Is this transparency or a final twist in a trial that refuses to follow any script? A case once built on Keefe D's confessions now dissolves under its own delays and shifting blame. Each postponement isn't just paperwork, it is erosion. If this is justice in real time, the clock is running out. The longer the wait, the more truth risks slipping through our fingers.